So when you file a summary judgment motion, you're going to want to have a cover letter. If you're in federal court, you generally don't have a cover letter, but you'll have your actual motion, which is usually just a one-page document giving notice to the other party that you're filing a motion and stating that you're asking the court for an order dismissing all or part of the case. There's a brief in support, which is your legal argument and your analysis of the facts in light of the legal argument. There's a document called Proposed Findings of Fact in federal court, and we'll talk about that a little bit more in a bit. And then affidavits or declarations. An affidavit must be used in state court, and it's just a statement made under an oath that's notarized. A declaration is used more often in federal court, where the declarant can declare under penalty of perjury that what they're saying is the truth. That does not need to be notarized, but there needs to be a very particular language in it. Whether you're doing affidavits or declarations, especially for new attorneys and paralegals, I would always go back and find what people have done in the past and cut it and paste it and reread it and make sure that it's proper, because that can be a real roadblock if you have an affidavit that doesn't indicate that the affiant swore or affirmed their testimony before the notary, that a court can disregard that affidavit. So it's very important what is on those documents. Legal argument. Why the case meets the legal standard for summary judgment. We talked about that a little bit earlier, always including a section, summary judgment standard, giving the basic information. Summary judgment should be granted when there's no genuine issue of material fact and the moving party is entitled to judgment as a matter of law, blah, 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 blah. And then talk about what a genuine fact is, what a material fact is, and then synthesize it to the particular type of case, the law or the facts that you have. Always put that at the beginning of the case. Legal arguments are provided in a brief authored by the attorney, and the brief is supported by case law and citations to the factual record. So the brief usually includes a short introduction, a very short facts section that will reference the proposed findings of fact. It includes the summary judgment standard, and then it talks about what the law is, what the facts are, and why or why not there are genuine issues of material fact. Putting the facts in front of the court. From an evidentiary perspective, summary judgment is a trial on paper. Whenever I tell people that summary judgment is a trial on paper, I get people saying, no, the judge doesn't decide facts at summary judgment. That's right. That's why, from an evidentiary perspective, summary judgment really is a trial on paper, and that's the best way to look at it. And whenever I talk to witnesses or clients and people who are not familiar with summary judgment, that's what I say. You are putting all of your evidence in front of the court, just as you would at trial. The rules of evidence apply. Evidence is filed on paper. It must be properly authenticated. Examples of proper evidence: deposition transcripts, authenticated documents. Authenticated means that there's a witness to say, I know what this document is. I'm familiar with this document. I sent this email. This is a document kept in the regular course of my business. Things like that. You can't just put in a stack of documents unless they're self-authenticating, but luckily this is not an evidence lecture, it's a civil procedure lecture, so we won't get into that. But for the most part, you need to have a witness say, I'm familiar with this document, this is how I'm familiar with this document, and then the court is allowed to accept the contents of the document into the summary judgment record. Then you need your affidavits or declarations. Affidavits or declarations will often contain facts and background information, and also references to exhibits. So an affidavit might say, this is my name, I'm an adult resident of the state of Wisconsin, I make this affidavit from personal knowledge. And then the next sentence will say, I was at the intersection of Main and Grand at 3:45 on December 22nd. This is what I saw. And then attached as Exhibit A is a statement that I gave to the police. So the affidavit is going to authenticate any documents that you want the court to see. Public or certified records, those can go into an attorney affidavit. Those are generally self-authenticating, which means that you don't need a witness to authenticate it, have personal knowledge of it if you have a certified record. And there are a lot of evidentiary rules around that. If you're dealing with public records or certified records or deeds, real estate documents, things like that, sometimes certified medical records, make sure that you're in close contact with your attorney with how to deal with those, because there are very specific evidentiary rules that need to be followed. And then video or photographic documentation is fine as long as it's authenticated, and courts can accept that stuff on summary judgment, videos, photographs, etc. But again, if you're going to be filing something a little unusual, if you want to file a video as part of your summary judgment record, I would get on the phone to the clerk and say, I need to file this video. How should I prepare it for the judge? Affidavit evidence, sworn testimony on paper by a party or witness in the action, somebody who has something to say about the case. Must be based on personal knowledge unless that person is an expert. When you have expert witnesses involved, it's a whole other ballgame that we're not getting into right now, but just remember, expert witnesses different than fact witnesses. You must identify the affiant's name, state of residence, and role in the lawsuit, or just explain why he or she is testifying. I am giving an affidavit because I work for the defendant employer and I'm familiar with the plaintiff's termination. So right off the bat, you want to explain to the court, this is why I'm here. Similar as you would if you're putting that witness on the witness stand. What is your name? Where do you live? What's your job? Stuff like that. You want to get that information in front of the court right away.
Affidavits are the equivalent of sworn testimony in court, so it's very important to make sure that the information being put in there is true. When doing affidavits, you want to start planning early. Identification of witnesses, who knows the stuff that is important to the case, who are the persons that you're doing an affidavit for, what information do they have that is relevant to the claims. Can I find that person? Maybe it's someone who's retired from the company, the agency, someone who maybe moved, things like that. Will that person willingly talk to me? In some cases, you will need to do an affidavit of someone who has left an employer under bad terms, and they don't want to cooperate with anything having to do with that company. Am I even allowed to talk to that person? Generally, it's opposing counsel, opposing party. You don't want to pick up the phone and call them and start asking them questions without their counsel present. Is that person available to talk about the case with me, or is he, she going on a month-long vacation to Egypt around the time I need to prepare this affidavit? Again, it's important to plan early. Keep in contact with the persons you know you're going to need information from. You don't have to contact them every week, but every so often in the case, send an email. This is the status of the case. What is your schedule like? This is what we're planning to do in the future. Will you be available? Who are your witnesses? I.e. the people who know stuff that is important to the case. Defendants, custodians of records, witnesses to the incident or possible crime. Maybe experts. Who will willingly provide an affidavit? Generally, your defendants will willingly provide an affidavit unless they're hostile, but sometimes you need to talk to a witness and they don't want to be involved. In that case, go to your attorney.
Yeah, sometimes there are third-party witnesses or people who are former employees of your client, and people say, you know what, I really don't want to get involved. If you need to get that person involved, you can subpoena them to a deposition, and sometimes that has to happen, and it doesn't have to be hostile. Usually you're allowed to talk to witnesses. Attorneys and paralegals are allowed to talk to witnesses who are not parties, and you can say, well, you know, I understand you might not be comfortable with an affidavit, but I do need your testimony, so I'm going to be subpoenaing you to a deposition. When are you available? Where are you available? Is it okay if you come to my office? How much time do you have? Stuff like that. A good paralegal is trusted to do those things and to make those contacts. It can be it can be a little difficult to navigate through, but again, being able to talk to people and be friendly and be comfortable in an uncomfortable situation is a very important thing for a good paralegal. You have a question? Okay.
Andy brought up the need for depositions. A deposition is part of the discovery process, as I'm sure most of you already know. And when doing affidavits, if information is in a deposition, sometimes you'll want to elaborate on that information in the affidavit. So be aware of what the person has said in possible discovery already provided. Personal knowledge requirement. If a party submits affidavits, they must be made on personal knowledge and contain such evidentiary facts as would be admissible in evidence, says the Wisconsin statute. What this is personal knowledge is what that person has firsthand knowledge of, and what they saw. Are they custodians of records, and do they have access to firsthand knowledge that is needed in the affidavit? What that witness can say on the stand. What does personal knowledge mean? Here are some examples. I saw Sally jump off the train. I signed the check. I graduated college in 1996. Obvious firsthand knowledge. When is personal knowledge not obvious? When you need to establish foundation. I was the hiring manager at ABC Company from 2002 through June 2014. In 2004, ABC Company hired Robert as its mailroom clerk. Would that person have firsthand knowledge that Robert was hired?
I'll just jump in really quickly. On the examples on the first page, I signed the check. You don't really need a foundation for that because the statement includes the foundation. I was there. I personally signed the check. I graduated from college in 1996. Of course, I know when I graduated from college. But sometimes it's not obvious. And when it's not obvious, you need to establish a foundation, because if I put a witness up on the witness stand and said, what's your name? And then said, in 2004, did ABC Company hire Robert? Objection, foundation, sustained. So in an affidavit, you have to put in the information and the foundation that would be required as though that witness was testifying on the witness stand. So establishing the foundation. The word foundation is just a legal buzzword that means background information. So the underlying parts and the blue parts are the foundation, the background information, and the thing that's really important to the case is the part that's in black and not underlined. So then we have a couple more examples.
Nancy and I compared our paychecks every month. We started doing this in May 2011. From May 2011 through August 2014, Nancy's paycheck was more than mine. I could say this because Nancy and I compared our paychecks every month and started doing this in May 2011. I arrived at work every day at 7. From where I sit, I can clearly see Mark's desk. I always noticed when Mark arrived at work because I could see him and hear the loud music from his headphones. He arrived to work every day between 8 and 8:15. Again, you have personal knowledge because you were there at 7. You could clearly see him from where you sat.
Does anyone have any questions about when you need to establish foundation? Because this is something, I know it's something that Jackie does just secondhand. I mean, she just automatically does it when she does an affidavit. But for new attorneys and new paralegals, I don't know if it's a difficult concept to establish a foundation. Are there any questions about that? Are there any questions about why on the back slide the underlined part is necessary?
I guess I have a question about why you were an example. Why? Can you go over that?
Sure, because when somebody testifies in court, they have to testify from personal knowledge. And that's a basic rule of evidence in any court. And that's a rule that is required of affidavits on summary judgment. So when you go to the statute and the rule and look at affidavits, you're going to see that firsthand knowledge requirement. And the example I gave, if you put somebody on the witness stand and said, "What's your name?" Betty Smith, and then just asked a question like, how much money did Nancy make in August of 2014? Well, how would your witness possibly know that information? It's not obvious.
Okay, I understand.
So you have to go back and say, basically, tell the court how you know about the thing that I really want you to testify about.
In an affidavit, you are establishing the who, the what, the why, the when, and the where. And if you don't have a complete story, the court isn't going to understand the facts any more than someone else who's coming in without having any knowledge of the claim.
So at the Department of Justice, we do a lot of prisoner litigation, and so inmates may have a lawsuit saying that they were forcibly extracted from their cell and that was excessive force. So here you have your affidavit. My name is so-and-so. I work at the Department of Corrections. On such and such a date, inmate Bob Lewis was taken out of his cell. He was calmly put in handcuffs, and then he started going crazy, and we needed to subdue him. That's all fine and good, but that's going to be stricken with an objection because it's not established that that person testifying has any personal knowledge. So what you're missing in there is on this date at this time I was at this place and I personally saw Officer 1 extract Mr. Lewis from his cell. And this is what happened. Otherwise, if you don't establish that that person saw it, or maybe they were in their little TV room looking on the video, and they saw what happened, and then they came running down the hall. But without that, and the attorney on the other side or the litigant on the other side moves to strike that testimony for lack of foundation and lack of personal knowledge, the judge should grant the motion. So that foundation thing is a really big deal. And I've had summary judgments before where opposing counsel will put in facts and just reference the plaintiff's affidavit. And the response is object and move to strike, because the plaintiff hasn't explained how she possibly knows this information. Maybe it's correct. Maybe it's totally truthful. But we don't know that.
So you file objections in writing in the context of summary judgment?
Yeah, and each court is different the way they want it. I think typically in federal courts, if you want to object or move to strike, that means have the court take out of the record a certain response. In proposed findings of fact, and proposed findings of fact are just lists of the facts that we want the court to consider, along with a citation to the affidavit. Where is the evidence? Just an arrow to the evidence. When I respond to that, I'll say object, move to strike, lack of personal knowledge, and then if it's necessary, I'll go in and explain, maybe cite some cases, cite whatever rule of evidence or civil procedure is applicable.
So you'd essentially have to get a ruling on your motion, your objection and your motion to strike before the judge would make a determination on the overall summary judgment motion, or am I confusing?
Well, yeah, no, I think, and I can only think of one time in recent history where I used it a lot, and the judge said there were a lot of evidentiary issues, but he didn't have to decide them because he decided the summary judgment motion on other grounds. One way to answer that question is to do a Westlaw search and look for decisions where there have been motions to strike testimony as part of summary judgment submissions, and judges will handle it differently. Sometimes, some courts will want a separate motion saying, I'm moving to strike these parts of the opponent's summary judgment submissions, or strike these portions of the affidavits from the record. Some courts want that in the brief, so they're not juggling with another motion and another filing and another brief. But I think typically what they'll do, especially in the federal courts who deal with this kind of stuff all the time, they'll say, well, there are some evidentiary problems. And really, when you object, you're telling the judge, you shouldn't even consider this. And if you're right, if there's no foundation, or if there's not a fact properly in evidence, the judge is going to say, well, I'm not considering this. The other side pointed out that this fact lacks foundation. I'm not going to consider this fact, or I'm going to, the motion to strike these certain facts is granted.
Do you find that judges generally, or the majority of the judges in the majority of the situations where you're involved in litigating summary judgment, they just decided on the briefs without any oral argument?
In federal court, they do.
It's always on the briefs in federal court, in your experience?
Never had an oral argument for summary judgment in a federal court. And I don't know if that's just the federal courts in Wisconsin. I haven't had any civil cases in federal district courts outside of Wisconsin. In state court, you generally do have oral argument.
But in either event, your paralegal or your legal assistants that are working with you have to be extremely detailed and organized. So when you're citing to, I imagine, some sort of appendix that you have with all the various affidavits from the various witnesses and references to deposition testimony, and perhaps even some exhibits, I don't know, photographs, maybe even documents, that sort of thing. I can imagine it can get pretty complicated, and you might be appending, hundreds, thousands of documents in some cases?
Sometimes. What I've done in the past with one of the attorneys that I've worked with is we've worked together. When a response to a proposed finding comes in and or when we need to respond to a proposed findings, and there's, like I said, hundreds, maybe thousands of documents that we need to cite in our response, we work on it together. I'll make the first pass through and match up the fact to the evidentiary materials, and I will cite it for her, and then she will go through and put in objections and legal conclusions and stuff. But we'll work together on it, and if I miss something, she's generally doing the same thing, so we'll make sure we catch everything, and then the document will go back and forth several times. You will review, like recently I did a proposed findings that had over 300 facts to it, and there was approximately 20 exhibits totaling 1,500 pages that you need to go through. It's not reasonable to think you're not going to miss something. So I'll make the first pass through. If I miss something, she's going to catch that, hopefully. And then I'll make a third pass, and it goes back for a final review.
Because I know my students are often rolling their eyes when I tell them to double check and triple check and quadruple check. We didn't rehearse this beforehand, but I mean, it's pretty fair to say in real world situations, you're going to double, triple, quadruple check before you.
I make indexes to documents. I make sure I know every piece of paper that is available to the attorney. And if they don't have access to it or can't find it, they should know they can come to me and I'll be able to find it by page number, by exhibit, however. I try to make sure I know every piece of paper in that file. You're not always going to remember everything, but you should have documentation to lead you back to it, guides, indexes, that sort of thing.
I think the way that I first learned about summary judgment, I was a law clerk and I had an attorney with a Clean Air Act case. I don't know if anyone knows the Clean Air Act, but it's really awful. I mean, it's wonderful, but it's very very complex area of the law. And he gave me a 40-page brief and pages of proposed findings of fact and affidavits, and he said, cite check the whole thing. And I spent probably 3 or 4 8-hour days going through, checking to make sure that every piece of evidence was cited properly. But that was absolutely the best way to learn. I don't remember, I must have learned about summary judgment and civil procedure kind of the way that you're learning now, and that, you know, planted the seeds a little bit, but it is something that's so complex and there's so many pieces of paper involved that I think the best way to learn it is to say, show me summary judgment submissions, and then actually go through, oh, here's a citation, and then that every citation is an arrow pointing to either a case where you're getting legal information or to some piece of evidence. So in the brief, you have an arrow pointing to the proposed finding of fact. The proposed finding of fact is just a list of the facts that you want the court to consider. And each fact, each separate, in separate numbered paragraphs, each fact lists the evidence, which is other arrows, where can this be found? So I might say Bob Smith was employed at ABC Company from 1965 to 1974, and then it'll say deposition of Bob Smith, page X. And so that's an arrow telling the court, here's where that evidence is, and you have to look at that evidence. And you might have an arrow pointing to an affidavit or to a exhibit, and that's how it's structured. I can't remember what question.
That was the question in terms of preparation, the amount of detail, and double checking and triple checking, making sure that every statement that you want the court to sign off on is supported by something in your submittal.
There's no fast way around it. It's a lot of work. The fastest way around it is to start early and be organized so you're not freaking out at the 11th hour.
All right, the format of an affidavit. You have a case caption. In that case caption, you'll have the court that you're in, Western District of Wisconsin Federal, Dane County, if it's a circuit court, something like that. you'll have the title of the document, such as Affidavit of Jane Smith, the county of issuance for notary purposes, and basically that is a little 3-paragraph saying State of Wisconsin, County of Dane. The affidavit, the paragraphs in the affidavit will be in a number format, 1 fact per paragraph. Identification of documents are cited in the affidavit. So, like if you're referencing Bob Smith was employed at ABC from 1972 to 1974, and it's stated in his resume, and you attach that resume as an exhibit, you will list that exhibit marked as a number, and then cite it back to that. And then notarization. Each affidavit needs to be notarized in front of that notary and signed in front of that notary.
That's really important, and I've seen a lot of lawyers cut corners. A lot of lawyers are notaries, and their clients might be in a different location, and I've seen a couple affidavits where the client will sign and date it, and then you see the lawyer has notarized it and dated it on a different day. That's a no-no. And yeah, your client doesn't want to go to the bank and pay $10 to get it notarized, but that's bad. Don't do that.
I have seen somebody try to notarize a document that they signed. Don't do that. You can't do that.
So just a point of clarification, if the case itself is filed in Dodge County, but I am swearing to it in front of you in Dane County, the caption is going to be a Dodge County caption, but that little byline is going to be referencing Dane County. Okay.
I mean, you'll have your case captioned, but it'll say State of Wisconsin, then a little SS, which means signed sworn statement, and then county of wherever the affiant is.
And that is not in the caption. The caption is a little box at the top, and it's always going to be the same for every, for that case throughout the case. And it's going to have at the top what court you're in. Then it's going to name the plaintiff, it's going to name the defendant, it's going to name the court case number. And then under the caption, you'll have the name of the document in its own separate little spot. And then to start out the affidavit, you will have where it's sworn to. State of Wisconsin, CC, County of Dane. So you can submit an affidavit in another court, even though you're signing it in another county.
Or another state. Mm-hmm. You might have clients in Minnesota, bless you, or Michigan. And so if they're in a different, if they're in Chicago, then it'll be, State of Illinois, County of Cook. And you can still file that in a Wisconsin court, but yeah, you have to say where the affiant is.
And your notary needs to be in the room, and you should say to them, I swear this is true and correct. Paralegals laugh a lot when we have to do affidavits, submitting documents. We'll do authentication affidavits, and we'll go to each other for notary services, and we giggle a little bit. It's like, yeah, I swear it's all true. But you should. I mean, that way they know you're not trying to get anything false in there. And it's just a little procedure, but it should happen.
It's I think for a paralegal, getting a notary stamp is really important. Even though it's like $50 and maybe the people you work for aren't going to pay for it, but it's really important to be a notary, and I think you're a lot more useful if you can do that for clients. And then you'll have lawyers coming to you saying, oh, can you notarize this? It's just a way to be helpful and be involved and
to expedite some things. Once in a while you're going to have a witness who is laid up at home with medical issues and they can't travel to a notary. I have gone to defendants' homes or met defendants somewhere that's convenient for them due to medical issues to provide notary services. So, whose testimony is it anyway? In the substance of the affidavits, it is important that the affidavit be the actual thought process and testimony of the witness, not the lawyer. The lawyer and the paralegal can help frame issues, identify facts, and then help the witness put that into words. At the end of the day, the signer, affiant, must be comfortable with the affidavit, that the affidavit is true and accurate and to the best of her or his knowledge. Basically, what I like to do is provide what I call a skeleton draft. I put in facts that are in the documents. I will help guide them on how the document should be laid out, but the facts need to be in their own words. You make your briefs based on the facts. You don't make the facts based on the brief. That makes sense?
And everybody has a different way of doing it, and it depends who your affiant is and how sophisticated they are. Some people need to be walked through it. Some people can really do it themselves. A lot of times I'll meet with clients and I will take a lot of notes. I'll get documents from them. I'll call them up, talk to them, ask a lot of questions, and I'll write up an affidavit and send it to him and say, this is what you have told me, but you need to go through it and make sure that this is right, and emphasize that this is your sworn statement. And people are usually pretty good about it. And I find that nobody likes to read anything ever, except witnesses are really good about affidavits, which is interesting. People say, oh, sworn, you know, I'm swearing that this is the truth. And we really emphasize that, and people will go through it line by line. They will move periods and commas, and they will drive you crazy, but it's really good that they're doing that, because they're the one that's going to be up on, if you don't get past summary judgment, they're the one that's going to be up on the witness stand, and the lawyer for the other side is going to give them their affidavit. Didn't you say this? So it's critical that it is the truth and in their own words, and not what the lawyer or the paralegal thinks they should have done or should have seen. So it's really a back and forth process, and again, you know, they don't give any psychology classes in here or in law school, but really a lot of working with witnesses who are talking about something that's uncomfortable for them, people who've been accused of sexual assault, people who are accused of race discrimination, defendants are accused of doing terrible things, beating up inmates, and they're vulnerable and they're scared, and so it's very important when doing these affidavits and working with people to develop those relationships. And that's, again, something that a lawyer doesn't have to do, and a good paralegal like Jackie will forge those relationships and work on affidavits with people.
It's very important that the affiant know exactly what they're signing. When I send a declaration or an affidavit to someone for review, in that email that I send it to, I have standard language saying, this is for your review. It is a draft. This is the equivalent of sworn testimony in court. Please review it carefully. Any changes that need to be made, please let us know. We'll make those changes. We want you to be as comfortable as possible. And I mean, it's quite a paragraph, but it's everything that they should know. And then when I get a draft back, I will call them and say, was there anything in there that you felt needed to be changed? Even if it was stylistic, if you wanted something rearranged in wording, let us know. Because even when we're making drafts, sometimes they'll think they don't need to change that paragraph, that's what we want. A lot of times affiants will try to give you what you want, and you need to make them know that you're defending them, that this is for them.
This is just as important, if not more, than build fact finding.
I mean, I think it's one and the same.
Yeah, that makes sense.
And it's very important to go back on past documents that they have helped draft or signed to make sure that testimony is consistent. Depositions, discovery, such as interrogatories, admissions.
And I think it's also important that the affiant not worry about the lawsuit. Their job is to tell the truth. That's their only job. And they might say, oh, well, I did this and I really shouldn't have done this, or this document doesn't look good for me. Can't we just pretend it didn't exist? No. It's the lawyer's job and the paralegal's job to argue, it's the lawyer's job to argue to the court why that fact doesn't matter, or why it doesn't mean exactly what it says, or this person was just joking when they made this comment. And to try to work with it within the legal framework. But the person who is making the affidavit, they have to say what happened. They have to be complete. They have to be truthful. And that's all they have to do. And so it's very important for the lawyer and the paralegal to emphasize that over and over again. I'm worrying about the lawsuit. You don't have to worry about that. You make sure that you're telling the truth. And I think people are very diligent when...
For the most part?
Yeah, for the most part. But the more diligent the paralegal and lawyer are, the more diligent the witness is going.
Communicating with your witness, gathering information. We've talked about this, how important it is to keep a line of communication open with them. Ask them the same question several times. It's important that you know the information that they are going to be speaking to. Time management, work backwards and start early. Telephone, email, face-to-face. These are all different ways you want to keep in contact. Like I said before, you don't have to contact them every week, but keep them appraised of the status of the case so, one, they remember you. Working with the Department of Justice, I will call somebody and they hear, hi, I'm Jackie Ryder with the Department of Justice, and people flip out. Why are you calling me? I don't think I have anything to do with that. And so you have to put them at ease right away. Let them know who you are, why you're calling, and what you need from them. Identify, authenticate, discuss documents and potential exhibits. It's very important to know who has custody of documents, who has information regarding those documents, and who can state that those documents are true and correct. So that way when you do your affidavit and somebody says, I'm the custodian of these payroll records, and it turns out that they're not, you want to be able to say, well, how do you have custody of these records? So it's good to know who has custody of what. May obtain resume or CV. Do you know what a CV is? Curriculum vitae. Again, information that is good to know for background when doing an affidavit, because you want to establish who this person is. It's particularly important for physicians, nurses, educators. And let your witness tell his or her story, but stick to the facts. A lot of times people will want to justify what they did in an affidavit, but you want to stick to the facts and how those facts came about, not what justification they had for it, depending. If you have an officer, perhaps in a case where an officer arrested someone, why? What was the justification there? But yeah.
Attorney affidavits. A lot of times in summary judgment, there will be an affidavit from the attorney, but they can only do a couple of things. You want to authenticate deposition transcripts. So it'll just be, when I do an affidavit for summary judgment, I'll say, I'm one of the attorneys representing the Department of Corrections in this case. I make this affidavit from personal knowledge and my review of the documents. On December 22nd, I took the deposition of so-and-so, attached our pages from the deposition that we reference, as well as deposition exhibits. And so that just tells the court that you can, that authenticates the actual deposition testimony, and then the testimony itself is sworn. So use attorney affidavits for that. You do not need to have your deponent authenticate the deposition. Authenticate discovery responses, and so there might be interrogatory responses that I want to put in to the summary judgment record, and those can be used, and it says in the rules that we talked about what constitutes evidence for summary judgment. Interrogatory responses, those are sworn statements. So I might say, on this date I served discovery on the plaintiff, on this date she responded, attached hereto as Exhibit 4 are true and correct copies of, a true and correct copy of the discovery response or interrogatory response. Submit public documents that are self-authenticating. Attached as Exhibit 4 are documents, are certified documents from the Register of Deeds, which just gives them a placeholder if they're attached to an attorney affidavit, so they're not just floating by themselves in space, so they have an exhibit number and a place. And you can also provide procedural information. Usually for summary judgment, it is not necessary to provide any sort of procedural information. Sometimes it is, and when I say procedural information, dates that things occurred, maybe I want to remind the court that there's a trial date coming up quickly, or any kind of information that is not germane to the facts or law, to the merits of the case. Attorney affidavit should not consist of testimony. I have received attorney affidavits that consisted of testimony, and that should never happen. So even if made from personal knowledge, attorneys doing a property case might go out and visit a property and say, you know, I saw this property and this guy's fence was encroaching on the other guy's property. That's not for an attorney to say. Even if you have personal knowledge, an attorney can't testify in a case in which he or she is representing one of the parties, and that's one of the ethics rules. And the affidavit should not contain legal argument. That's solely for the brief. So attorney affidavits are something that paralegals routinely do, and in preparation for summary judgment, if I'm working on a brief without even having been asked, Jackie does a shell affidavit for me, affidavit of Bensky. It says my name, says how I'm connected to the case. I'm one of the attorneys, and then has exhibits for when I took, or has paragraphs when I took depositions, and here are exhibits attached. And that's something that paralegals just kind of do, you know, automatically.
And just so you know, when we authenticate depositions and discovery, it's so that it's in the record and you can cite to it in your affidavit, or most likely your proposed findings of fact.
And then finally, proposed findings of fact. We jumped ahead and talked about this before. What are they? It is a document that lists the facts that you think are material to the case. It can also list background facts. So this is usually always required in federal court. In state court, it's generally not required. I usually do it anyway if I'm filing a summary judgment in state court, because that's what I'm used to, and I think it's easier for courts to deal with, and it's easier for the other side to respond. The proposed findings also tell the story of your case, though, and when I'm working with a paralegal on the facts, I usually set out a shell of how I want the story of the case to be told. What's this case about? Who are the people? What's the background information? What happened? There are a lot of different ways to organize a story, and I think anybody who's ever seen a movie, sometimes there are flashbacks that work and sometimes there are flashbacks that don't work. It's the same thing for proposed findings. Most people do them chronologically. It's usually the best way to do it, but not always the best way to do it, depending on the facts of your case. You may have several different defendants who had different roles in the same incident, and the facts will be organized to talk about what each defendant was doing. There's no hard and fast way to organize the proposed findings. It's something where you're going to be working very closely with your attorney. But again, a good paralegal is going to come to the attorney before summary judgment is due and say, I was thinking about the facts. I know we have affidavits from these 4 people and we have depositions from these 4 other people. These are the different categories of information that I see, and this is how I propose laying it out. Did you want to say something else on that?
Very much like Andy said, a lot of times what I'll do, depending on the attorney that I'm working with, I've worked with an attorney, one specific attorney, for about 8 years. So I know what he prefers. So when it comes to the facts, I'm able to lay everything out in a manner that is going to best serve his needs in preparing the brief. He will let me know what facts he needs. We'll talk, discuss the depositions, affidavits, and we'll make sure all the facts are in there. Depending on the case, like Andy said, it may be chronological. If you have a medical case where an inmate claims, or a medical case where somebody claims, I stubbed my toe on this date, I was provided this medical care, I wasn't provided that medical care, you can lay out the chronology of that case in the proposed findings, so where it's an easily read story to anybody who's reading that proposed findings.
One thing that they don't teach in law school at all, and I don't know if they teach in paralegal programs, is that I think the most important quality of a good paralegal and a good lawyer is somebody who can stop and think. It can save you a lot of time, and it can win you cases. And you're laughing because it sounds silly, but it's true. And when you have a complex case with a lot of people involved, you've been living the case maybe every day for the last month, but the judge has no idea who these people are, no idea what the claims are, maybe looked at the complaint, and probably has to read 4 of these in one day before he has to deal with a week-long trial tomorrow. So it's important to organize the facts in a way that somebody who's completely cold to the case is going to understand them. And a lot of times it might take coming up with, well, we could organize it this way, we can organize it this way, think of a couple of different ways to organize it, and then show it to another lawyer or a legal secretary or another paralegal who isn't working on the case and say, does this make sense to you? I think that's so important in the facts, to make sure that the judge understands what's going on, who did what, when it happened, why it's important, and organize them if you can to tell your client's story and have that theme in mind. We've talked a lot about what separates a good paralegal from a great paralegal, from a phenomenal paralegal, and there are some paralegals who are technically very good and always have their T's crossed and I's dotted, and but they don't, they'll do exactly what they're told and that's it. That's great, but somebody who goes above and beyond is somebody who really sits down and thinks about this and can say to their lawyer, well, the facts are laid out this way, but when we did the affidavits, I think it might make sense to lay the facts out a different way. And I mean, every lawyer is different, and our last slide here is you and your lawyer have to be best friends. You have to trust each other. You have to respect each other. You have to be honest with each other. You have to know what the other one is doing. But I think it's absolutely the role of a paralegal to be looking at the facts and the affidavits critically, deciding what makes sense, what is important, and really understanding what you're trying to do with summary judgment, because having somebody else's brain in the case, especially in something as complex as summary judgment, really can make the difference between winning a case and losing a case. Being an attorney and working with a good paralegal on a case is just like it flows. When you're working with a paralegal who's not paying attention and not thinking, then it can really slow down the process. And I think every paralegal has the ability to be involved and be interested. So I think that, I guess I'll leave you with.
Any questions? Yeah, please.
It's not so much a mechanical question, but, of course, attorneys and paralegals have options where they want to practice, and I was just wondering what attracted you to the Department of Justice?
Well, one main thing was having a case with Monica. This is our colleague and mentor, Monica, who's been an attorney at the Department of Justice for a long time. I had a case against her when I was in private practice, and I was so impressed with the way that she handled it. I realized that the Department of Justice would be a great place to work if there are people like her working there. Also, the work is interesting. We do a lot of civil rights work. There's a pretty big variety of work, and it kind of has the best of both worlds, where the attorneys have a lot of autonomy to work on their own cases, but there are 100 attorneys there and a ton of support staff, so there's a lot of resources too. I think that's important, having a nice place to work where you're interested in the work and you like the people and you believe in what you're doing.
Feels like, or I sense it would be for the greater good too.
Yes.
We like to say most of the time we get to do justice at the department.
Yeah.
Right. Yeah. Yeah.
What attracted you as a paralegal? I'm interested in knowing a little bit about. You preceded me, or at least I think you were there before me.
I came in 2001, and actually it was a little bit of fate. I was working at a small firm, and the partnership was splitting, and so I just put out a couple of resumes, and I heard back from the Department of Justice, and it was during the hiring freezes, and I had 2 offers, one from another small firm closer to home and one from the Department of Justice. And the reason I chose the Department of Justice was the unit director I was dealing with in the hiring. I liked what she had to say about the Department of Justice, the unit that I was being offered a position in. The role, at the time I was a legal secretary, the role of legal secretaries in the cases, and the Department of Justice's role in statewide claims, the different types of cases. So that's why I chose the Department of Justice. But the decision came in less than 2 hours. I was told, the job is yours if you want it. We've got till noon when the hiring freeze takes place. Please let us know. I'm like, done.
Wow.
But yeah, the unit director who was hiring me I was very impressed. And I can say that it continues to be that way with the people that I get to work with. I do like the work that I do, but the best part is the people that I work with. They're really good resources. If ever I have a question, I am very comfortable going to just about anybody in our unit to answer that question. And we have a lot of experience.
Comes back to personal relationships.
Just one follow-up. It's not exactly on point with what we're talking about, but a lot of times I find that students, they want like the answer, like tell me how to do this, like as if there's only one way to do it. And I try to explain, obviously, that we have 3 or 4 attorneys in this room, and we're each going to have our own individual styles and ways of doing things. Jackie, how many different attorneys do you work with at the Department of Justice?
Regularly, I generally tend to have 2 to 3 attorneys, but overall, it can be anywhere up to 14 different attorneys at one time.
So obviously 2 or 3, and there might be less variability in terms of their styles and their expectations and the things that they want. But obviously, if you're expanding it out to 14, they're going to be very different styles. And can you kind of sort of speak to that for students? Their need to be flexible and be willing to, I guess, kind of go with the flow in the sense that if Bill says that he wants the affidavit drafted this way, do it that way, and if Monica says she wants it slightly differently, do it the way she wants? I mean, can you speak to that at all?
I tend to keep notes about the attorneys. I mean, I have a little pamphlet on each one. Same thing that I do with the courts. If I know that Monica likes something a certain way, as I work with her more and I learn more about how to work with her, I will keep notes and I will try to stay at her particular style. As I work more with Andy, I'll do the same thing. But you get to know your attorney and you need to know their rules as well as the courts. But when it comes to affidavits and proposed findings, the best thing to do is just be all-inclusive. It's easier to take things out. So if you're not sure a certain fact is relevant, add it in. The attorneys are going to look at it. They get to decide what is relevant and what they need. And then it'll go to the reviewer. But stay flexible. You don't get to decide what the style is going to be, but try to be understanding of who you're working with and what they need.
Excellent. Well, thank you both so much for your time. We sincerely appreciate it. Let's give them a round of applause. Thank you. And with that, our program has concluded.